Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. This is Calum Cheyne. I'm Luke Zadkovich.
Every episode, we read a case independently of each other. We jump on the podcast, we hit record. So what you get is our raw thoughts on that law.
And we're super excited with some of the guests we've got coming up on future episodes. So keep an eye out.
And if you like the podcast, all we'd ask is that you hit subscribe and share with your network. Okay, let's get into it.
Let's do it. Welcome to Case by Case. This is a podcast brought to you by Calum Cheyne and Luke Zadkovich from FZ. How are you today, Calum?
I'm very good. Very good. How are you doing?
Good. I'm a bit sore. I've been doing a lot of kind of triathlon training recently, but other than that, I'm in a great mood. Endorphins are high.
Yeah, I've been overdoing it as well the last couple of days, having underdone it for about 6 weeks. I've flicked back into training in a way too big way, which is causing me all sorts of pain and bad sleep and the rest of it.
Yeah, I know the feeling. Look, that's probably a topic for a whole nother podcast, you and I, now, our triathlon training. But anyway, more importantly, we are joined today by a very special guest from Essex Court Chambers, David Walsh KC. David, welcome.
Thank you very much for having me.
Oh, we're super excited to have you on and to get into a very juicy topic. But no, yeah, great. Have you done one of these podcasts before? Is this something that's new to you?
Never with video. So
okay.
I approach you with some trepidation, but I know you're a veteran, so you can guide me through this.
I don't know if people watch the video or listen to the audio more. I'm sure that we get stats on this, and we can speak to Fiona and our marketing team and work out whether people tend to prefer the video or the audio. I guess audio. I tend to listen to podcasts rather than watch them.
Yeah,
I'm going to say
it tends to be on in the background for me when I'm doing something else. But.
Yeah, well, we've had a bit of feedback. I think most of the audience feedback, Callum, is audio. We've had someone who spent 3 days painting their house that listened to the whole back catalogue and hadn't come across. And I'm like, I don't know what to make of that. Like, is that a good thing? Probably. But yeah, dude, people on their commute, in the gym, these kinds of things. So all good. So anyway, I forget the videos there. I should probably pay more attention to the video. But yeah, so look, I'll just give a quick introduction to David and his practice. He's a KC for those in the know. That's the King's Counsel in the UK. One of the top barristers, recognised as such by peers and the market, and has a particular focus in dealing with shipping, commodities, international trade, energy, insurance, reinsurance, and I'm sure there are some others there that I'm missing as well. But very much in that core sector space that we work in, and we're very fortunate to know David well on a number of things. And so a great guest to have to talk about the topic that we've got today. But I just wanted to open with a couple of kind of non-case specific kind of topics, David, to get to know you a little bit. So what kind of piqued your interest about this niche in the law? What is it that kind of pulled you into this area?
Well, in terms of this specific area, which we're going to be talking about, which is limitation, I have to say that before this case that we're going to discuss, which is the Flaminia, we'll introduce that in a moment, I hadn't really touched on limitation of liability for maritime claims before. I'd always been a shipping lawyer. I'd always been involved in charter party disputes, cargo claims, that sort of thing. But limitation had, for whatever reason, had not really come up in my practice. And I don't know about you two, but my experience has been that your specialisms in the law find you rather than the other way round. And limitation became something that that I lived with and grew to find extremely interesting during the course of the limitation proceedings in the Flaminia. The case obviously had a life long before limitation, but limitation is what's been occupying us for the last 3 years or so.
Yeah, absolutely. And look, and I think these these cases on limitation, particularly ones that go all the way to the Supreme Court, as we have here, they don't come around all that often, right? And a lot of the issues that kind of percolate up here are often dealt with by negotiation and through insurance, payouts and what have you. And of course, there are some very key issues. I think it's a great judgment to really explore today that we'll get into, but I think a lot of them are dealt with in the earlier phases by way of resolution, and they don't come along that often. We're talking about big casualties. Yes, there are still a good number of them out there, but it's decreasing. This is an area of law where ships are getting more efficient, safer. Thankfully, incidents like this, and we should recognize that there is a somber element to this case in that there was loss of life. Thankfully, that the prevalence of these types of incidents, generally speaking, is decreasing. So, yeah, I think that's right. They don't come along all that often. But the nature of them, as we're going to learn, is once gripped by it, it kind of really gets you in. And I'm sure you could write a book on this topic, having run this case all the way through. What's your experience, Calum?
Yeah, I mean, we haven't seen a huge number of these, as you say, Luke. They're fewer and further between. I liked what you said there, David, that your specialisms in law tend to find you. I think it's very true. You can, with the best will in the world to go in a certain direction, you find interest in a case that gets sent to you, or a series of cases that get sent to you. And before you know it, that becomes a real niche area of expertise. And I think one of the great things about this area of law, and to the extent there are any kind of young lawyers or aspirant lawyers listening, I would very much encourage a career in the law around international trade, because it is so varied. It feels like a niche, and you speak to people and say that you're a lawyer in this international trade world, and they think, oh, that's quite a niche job. And actually, no, that's a very broad job. The niches within this job are far narrower. And everywhere you peel back another layer, there's more and more to become an expert in. And I can imagine, I was going to ask you, David, when did you first hear the words MSC Flaminia? I imagine it was nearly a decade ago or something.
Yeah. So, I mean, I was aware of the casualty. So the casualty was back in July 2012.
Yeah.
But only in the sense of being aware of it happening, not actually having any immediate involvement. But I first started work on the case in the arbitration, and I think I was probably presented with a file that had the words Flaminia on it in about 2016,
right?
2017.
Yeah.
Obviously, this is one of those unusual cases where a little bit is actually known about the arbitration from the fact that the court proceedings followed, which actually set out in a little bit of detail what happened in the arbitration and the result of the arbitration. Because obviously, for any younger lawyers listening, normally those would be kept confidential and would never see the light of day. But yeah, so I was first involved in the arbitration so it's an arbitration between the owners and the charterers. The owners, Conti, unless you want to go with the extremely long German version of their
Conti will do.
and MSC. So Conti the owners, MSC the charterers. So
yeah, and just chiming in there, I'll give we've got some citation lovers out there, so I'll give the full case name. It's the MSC and Conti case, known as the Flaminia, name of the vessel. This is a citation of 2025 UKSC 14, and we had Lord Hodge, Lord Briggs, Lord Hamblin, Lord Leggett, and Lord Burrows, with judgment given on 9 April 2025. Lord Hamblin gives the judgment here, with whom the other lords all agreed. So yeah, look, maybe we'll just jump straight into it. I think we've got a lot to get through. And we should, make clear at the outset that today's discussion is about the judgment. So, we are looking at it as though we're kind of, particularly us, but I'm talking primarily here about David, in that we're not looking for kind of inside information, kind of behind the scenes stuff, even though it's kind of got to the conclusion it has at the Supreme Court level. We're kind of unpacking the judgment, but no doubt, who better to speak with about this case than someone who's been handling it day in, day out, all the way through, at least in the appellant stages. So, yeah, with that all said, where to start? Should we maybe talk about the incident to some extent and just kind of set the scene a little?
Yeah, happily. So the vessel, the MSC Flaminia, was a container vessel, still is a container vessel, been repaired since the incident, and it was going to it was loading a cargo of containers in the US, and 3, I think, of the containers that were loaded contained a chemical called divinyl benzene, or DVB, about which I now know way more than I ever needed to know or wish to have known. But and what happened was, it was effectively the containers were left in the sun for too long in New Orleans before they were loaded onto the vessel, and the inhibitor, which is there to stop the cargo, what's called autopolymerizing, basically ran out before the vessel, before the cargo was loaded and before it got onto the ship. So midway through the voyage across the Atlantic, the cargo starts autopolymerizing. Somehow or another, there's some kind of spark that is caused, which causes the cargo to explode, and a fire to ensue. You already mentioned, Luke, that there was some loss of life. 3 members of the crew lost their lives. The vessel is salved by Smith, taken across the Atlantic, and is taken to a port of refuge at Wilhelmshaven in Germany. So that's the sort of basic outline. Obviously, if you Google MSC Flaminia, you'll see some images of the extent of the damage. It's really, really quite extensive, as you might imagine. Essentially a massive hole in the middle of the ship, for want of a better expression. And yeah, so that's the casualty. And obviously then what ensues is a very long and painful exercise, traipsing around a number of countries in Europe to get the damaged cargo off the vessel, get the firefighting water off the vessel, and get the vessel repaired and put back into service. And remarkably enough, if you see the images, you think, that'll never ever sail again, but the vessel gets back into service and is back in 2 years later.
Quite a feat, huh, to get that vessel repaired.
Yeah, and the claim that the owners then bring against the charterers in the arbitration is for about $200 million for all of the costs of repairing the vessel, dealing with the damage, and so on and so forth. So that's the claim. I don't know if you want me to explain what happened next in the arbitration, but
I was going to say next. So if I follow the procedural history correctly, you then have an arbitration, which is a claim brought by the owners against the charterers, and the owners succeed in that arbitration. And then, rather than appealing the decision in the arbitration, the owners, or maybe alongside an appeal, I'm not sure whether there was separately an appeal, but it seems like owners then launched limitation proceedings, which are their own beast. And we should talk a little bit about limitation proceedings, but I wanted just to clarify that procedural background with you.
Yeah, so it's the charterers that issue the limitation.
Charterers, pardon me, yeah.
So the owners get an award for 200 million odd in their hands, and they say, right, well, we now want to get our money, please. And the response from the charterers is to constitute a limitation fund in the High Court, in the Admiralty Court in London. And they say, look, you've got a $200 million award there, but under the provisions of the 1976 Limitation Convention, we can limit that liability to about $28 million. And that $28 million figure, for those that aren't aware, is calculated under the convention by reference to the tonnage of the ship. So you get a certain amount effectively of dollars per ton of the ship, and that fixes your liability at, in this case, $28 million.
But can we just pause there for a moment? We're probably going to ask the same question.
Exactly, I'm sure we are.
We've got, which is for not the first time, but we've got a lot of listeners who are deep in this world, right? They know what limitation means. They know that they probably know the case already and interested to hear the summary of it. Many dear colleagues of ours, including former colleagues of mine, actually kicked off when I was still at HFW. So I know Chris Garley and the team there really well who handle this. Anyway, we do though, quite pleasingly, have listeners from all sorts of kind of areas of law and not even in law, but just interested in the podcast. So perhaps we could just give a bit of an explanation about what is limitation. What are we referring to here? Why can a party limit its liability in international shipping? And I know some of the answers to those questions, but let's get that discussion going. Like, what are we talking about here?
Because I think at first blush it feels slightly unfair. If you're in the owner's shoes, you go through an arbitration, you get this award for $200 million odd, and your charterer turns around and says, "Okay, understood. We owe you $200 million, but actually we're going to apply for some other remedy." We don't think the award is wrong. We just don't think that we have to pay you all of it. That's a pretty unusual remedy, if you like. I don't know whether it's properly characterized as a remedy or a defense. There actually was a case very recently that looked at exactly that. But I think it is unusual, and it's worth a bit of explanation as to why it exists and how it operates.
Yeah, so I mean, this is explored a little bit in the judgment for those that have got an interest in it. But limitation in the maritime context has got a long history and pedigree, and essentially the principal reason for allowing claims to be limited in this way is for owners, and we'll come back to what that means in a minute, to fix their maximum potential exposure so that A, they can insure against those liabilities in a cost-efficient way, and B, so that the costs associated with international trade are effectively kept to a reasonable level, so for the benefit of the wider public, for the benefit of the maritime community. So if you look at some of the Travo for the earlier conventions, this all comes about to try and make sure that to encourage shipping in the world, to encourage the number of ships being produced, mercantile ships being produced, and to therefore bring down the cost of shipping, and the idea being that everybody benefits from generally shipping costs being lower. And of course, you're right. The flip side to that is there will be circumstances where parties are deprived of a full remedy. But that's why there's always this trade-off as to where you set your limit and which claims are subject to limitation and which claims are not subject to limitation. And that's really where we get to here. I guess the only other point to mention at this stage is I referred earlier to the fact that it's about encouraging shipping and in protecting owners. And what has happened, if you look at the history of the conventions, is that over time, who falls within the category of an owner has expanded. So it's gone from including the registered owners only to the registered owners and the bareboat charterers. And then under the 1976 convention, the term is defined to include charterers, owners. Sorry, the term owners is expanded to include the charterers, the managers, and the operator of the vessel. So all of those effectively can then fall within the definition and then take the benefit of limitation for the claims that are within the convention.
Yeah, exactly. And the way that I kind of think about it is if there wasn't a limit on the potential liability for owners as now as an expanded class, the potential exposure could just wipe out, those participating. It could be really, really large. And as it is, the numbers are very significant, of course. And so, yeah, it's this concept of there needs to be some limits. And the reason it's international is because, we're talking about a global market, and there's an interest in having a kind of level playing field internationally. There's interest in harmonizing that and making sure that, one part of the world's not preferred over another. And so there's a lot of kind of underlying factors at play there.
Just picking up on one point there, Luke, and you're right to mention the international character of this. And obviously, these conventions have a number of signatories from countries around the world, but not every country is signed up to the 1976 convention. Not every country is signed up to any convention on limitation. And for those interested, there's another judgment in the Flaminia litigation that effectively the first time that the matter went before the courts, which is not really what we're talking about today. But for those interested, it's a reported decision of Andrew Baker, it's just Andrew Baker, the Admiralty judge, on whether you can effectively, if a party sets up a limitation fund, you can choose to go after any assets that they may have in a non-limitation state instead of going against the limitation fund. And spoiler alert, the answer is yes if you haven't elected to claim against the fund. And so, and the reason for mentioning that is that in that judgment he explains it's not, there's no unanimity on the approach to limitation internationally.
Of course, that's absolutely right. I suppose the perspective I was kind of introducing is that when it comes to matters of construction and to understanding the convention, there is an interest in harmonization in the sense of how you construe the convention. And it's interesting in a way because I think as we're going to come on to looking at some of the specifics here, you have a bit of a balancing act between looking at the literal interpretation of the convention. And we know that, there's been, you could say, almost increasing approach to construction under English law of literalism, I think. Whereas in a convention analysis, you can bring in kind of more secondary sources, Travaux, object and purpose, history, and things like that. So you actually are allowed a more purposive approach under a convention, but at the same time, courts are reluctant to stick their nose out or their head out and have some different interpretation that may not be uniform as applied by other countries. But you're quite right to note that not all countries have signed up to the convention.
And it makes, I think the way that the court interprets these kind of international conventions does mean that you sometimes see, as here, a lot of fluctuation between the courts. Because, the decisions between High Court, Court of Appeal, and Supreme Court are entirely different all the way up.
They all reach broadly similar conclusions, but each for different reasons.
Right, exactly. And it's an interesting one. And I do wonder whether that part of that is that the mechanics of the construction of the convention are slightly different to how the court would be construing a set of contractual terms.
I think that's right. I think also it comes back to the point that I think Luke made earlier, which is these cases don't come along all that often. I mean, if you've got an idle afternoon, you can read all of the decisions from the English courts on limitation easily within that time frame, because there's only about 5, and then you've read the entirety of the jurisprudence in this area. And so there's not always an awful lot of guidance. And I think sometimes you're looking at these cases and thinking, and this is kind of where we were at the start of this process. Is there an underlying rationale that these judges are sort of grasping towards, which they haven't quite expressed in the previous cases?
And is this the kind of home team, away team case theory?
Insiders, outside.
Insider, outsider, yeah.
Loads of different names. The genus, I think we called it originally. Insiders, outsiders was an innovation of the judge at first instance. But yeah, you're right. That's where that came from.
Yeah. Because I'd be interested to hear the sort of case theory behind that, thinking, as you say, thinking through what's the thread through the other cases on limitation, that then you then come up with this kind of insider outsider argument, which
short-lived as it was.
But I think does it succeed at the High Court, or does it succeed at the Court of Appeal?
It succeeds in the Court of Appeal. So yeah, a variant on it succeeded in the Court of Appeal.
Right.
But to answer your question, I mean, the theory looking at it was that the judges who had considered the convention previously in England, so you've got Mr. Justice Thomas in the Aegean Sea. You've got Mr. Justice David Steele and Lord Justice Longmore in the Sea of Major Carter. They're the main cases, and there's some obiter consideration of it by Lord Clark in the Ocean Victory. But they had been struggling with the idea that a charterer could take advantage of the limitation convention. And it's this idea that, well, why does the charterer get to limit a claim against the owner for the owner's losses by reference to the very ship, the tonnage of the very ship that the claim is in respect of? So it's that, I think there was a sort of gut feeling that wasn't right. But none of those judges explains the analysis in terms of everyone within the category of owners can't limit against each other or anything like that. But it felt like that might be an underlying rationale for why they'd reached the decisions that they'd reached, which is effectively charterers can't limit for the claims that they were trying to limit in respect of.
And this goes back to what you were saying earlier, which is that the scope of who falls under, who has the ability to grab this limitation has been expanding.
Exactly.
It now includes charterers, and in this case, you have a claim brought by the owners, and historically, owners have the benefit of the limitation, and now the limitation is being flipped against them, and charterers are saying, "We're going to use this limitation to prevent your claim from succeeding against us." And the argument, the inside or outside argument, in very unsophisticated terms, was effectively, "You can't do that because you're all owners for the purposes of this limitation."
That's right, and just to be absolutely clear, Conti was never arguing that the charterers couldn't take advantage of the convention for what we call third-party claims. So a classic cargo claim where the cargo owner is suing the charterer, perhaps who's issued the bill of lading and is the carrier, because that's exactly the sort of claim that you would expect a charterer to be able to limit in respect of. And the whole point of expanding this category was so that you didn't get a situation where the owners as well, the registered owner says, well, you can't sue me, my claim's limited. And they just say, well, okay, we'll sue the charterers, forget the claim bailment against the owner, we'll sue the charterer in the contract of carriage instead, and bypass it in that way. So that was never the argument. But yeah, so it was trying to rationalize the decisions that had gone before. And the argument of first instance was that anyone that was in that definition of owner couldn't use the convention to limit claims brought by the other in respect of their own losses. And that argument was rejected at first instance by the Admiralty Judge, Mr. Justice Andrew Baker. And so we refined it in the Court of Appeal to say, well, forget the entire category. You don't need to decide how it works in respect of every member of this category. All you need to decide is whether a charterer can limit in respect of the owner's own losses. And that argument was accepted in the Court of Appeal and then rejected again in the Supreme Court. So that's a sort of potted history of that.
One point on that, sorry to interrupt, is the argument to me seemed to proceed almost on a historical basis, in that it was the limitation is about protecting the owner. And, I could see that argument, kind of pre-expansion of the group having more force. But once the class has been expanded to include charterers, managers, operators, as I was reading the case, not with the history or deep knowledge about how the arguments came together, my initial reaction to that argument from a commercial perspective was to say, well, why can't a charterer set up business and charter in vessels and have this structure, whether it's with a financier involved or in this case, having a charter party with an owner, on the very basis that they expect to be able to limit for those types of claims that are set out in a limitation convention. Once the changes had been made, without restriction, without an express gloss on them to expand the class, then surely it's well within the rights of a charterer to set up business on the basis that they can expect to limit certain things. Because, a charterer, particularly a charterer like this one, can have its own vessels if they want, or they can charter in vessels. And there may be some reckoning to that, or some analysis as to what the potential liabilities are and how they split their fleet between owned, like properly owned tonnage themselves, chartered in tonnage, etc.
Well, the Supreme Court thought that was a good point. And that's why what some textbooks called the Flaminia rule after the judgment in the Court of Appeal was rejected. I guess the other is, you're right in the sense that the argument was had sort of historical basis, but the other basis for the argument was that under Article 11 of the Convention, if an owner, by which we mean anyone that falls within the definition of an owner, constitutes a limitation fund, that fund stands to the benefit of everybody within that group. And the argument we made was that can lead to absurdity, because you end up with scenarios where the owner constitutes a fund, and the owner then brings a claim against the charterer, and the charterer says, "Thank you very much. You've constituted a fund, and that stands to my benefit, and you have to prove your own claim on your own fund," which not only sounds absurd, but also means that the claims that the parties to the convention principally had in mind as being for limitation, i.e. cargo claims and the like, are reduced by the owner's own claim on its own fund. And so that was the other limb of the argument. Now, obviously, the Supreme Court thought that absurdity wouldn't arise all that often. It wasn't really a good reason for construing the convention in a different way. But that was the other limb of the argument.
Yeah, and I think it's interesting thinking about this from the perspective of how international conventions develop over time, right? And perhaps cases like this, as irregular as they come along, help inform the next round of negotiations on the convention. So, as we know, one of the issues historically was that it was relatively easier to bust open the convention. And then that was tightened up in one set of changes to the convention. But the flip side was an increase in the threshold and the increase of the limit of what the total amount of what the fund could be. And I just wonder whether, as these cases develop, there will be a reassessment of whether the level of the funds is at the right point, because the type of point that you're making there, I can see hypothetically sitting around a table discussing what the threshold should be for a fund. So, well, these are the types of claims that fall in and fall out, and actually the number, like the actual quantum of the fund, is too low to include those other types of claims. So I can see that kind of playing out in years to come. Thoughts on this, Calum, or next topic?
Yeah, I just find it fascinating that you have this area of law where we all know, what limitation is. We all know kind of how it exists, how it's supposed to operate, and then and yet you have these really interesting discussions around who falls in a limitation, who can use a limitation against who. And as you say, David, that it's very easy to point to the absurdity of one outcome and say, this is absurd because what about this context? Take the example that Luke brought up. But you can equally point to absurdity the other way and say, well, it's absurd that owners can constitute a fund and charters then stand to benefit from it. Or the owners then have to prove their own. Yeah,
exactly. And the Supreme Court judgment doesn't resolve all of those issues.
Yeah.
So how does it work when one of the claims is by the owner on its own fund? The court says, well, it's not going to happen very often because most of the owner's claims are going to be for damage to the ship and they're not within limitation. and precisely how it works in terms of claiming on your own fund, well, that doesn't arise on this case. So we'll wait and see until we have a case where this is a relevant issue. So it's not like it's the final word on limitation by any means.
True. And there may be, as Luke says, a more, and a further revision to the convention. But what you introduced there is a nice segue on, I think, because you say the damage to the vessel does not fall within the limitation, which moves us on to what does and what does not fall within the limitation. Because that was effectively the other battleground here. Are the claims ones in respect of which the limitation applies? And again, it's not consistent all the way up. The High Court says, these are all claims of a certain class, and that class is not one that falls within the limitation. The Court of Appeal then says, no, you can split out the claims into many different classes, and some of them fall within the limitation. And I think by the time it gets to the Supreme Court, the scope of the claim for the limitation is fairly reduced by, what charges are claiming is fairly reduced to those claims that perhaps more naturally fall within the convention wording.
Yeah, I think that's right. So the Admiralty judge at first instance said, well, there are various claims that were brought. Some, for example, the loss of life claims, the owners had always accepted were limitable, so that wasn't part of the discussion. But what was left, the Admiralty judge said, look, what you've actually got here is one single claim for damage to the ship caused by the cargo blowing up and consequential losses flowing from that, which the owners suffered. And that can be categorized as one claim, and that doesn't fall within any of the limitation categories. He then went through all of those categories and said, well, even if I'm wrong about that, it doesn't fall within any of the individual categories anyway. So he found, although he rejected that in the insider-outsider argument, he basically said, well, whether you look at it as one big claim or lots of little claims, nothing's limitable. And then you're right, then you get to the Court of Appeal. The Court of Appeal accept the modified insider-outsider argument and then say, but if we're wrong about that, then none of the claims are limitable anyway, apart from the claims under Article 2.1e, which is all about removing the cargo from the ship. And then when you get to the Supreme Court, the modified insider-outsider argument, which had won the Court of Appeal, is rejected. But the Supreme Court basically adopt the same analysis as the alternative analysis of the Court of Appeal. So nothing's limitable apart from that one set of claims for removing the damage to the cargo under 2.1e.
And can you just unpack this claim characterization argument a bit? Because I struggled with that when I read it. The idea that the way that the claim is presented in some way could affect whether it's limitable or not, as opposed to looking at the actual character of each part of the claim or the claim itself. Like, I struggled with that type and ultimately didn't prevail. But can you just unpack that a little bit as to how that played out?
Yeah, well, there was a battle all throughout as precisely, it's almost, whose shoes are you standing in when you're looking at all of this? Are you looking at it from the perspective of the claim is presented? Are you looking at it in terms of causes of action? Are you looking at it in terms of motive? Are you looking at it in terms of causation? And none of those arguments and questions are easy. But in the end, I think what we can say with certainty is it's a matter of substance. Certainly when you're looking at 2.1a, you're looking at the substance of the claim that is being made. And that's the claim that's being made by the owner for damages against the charterer. So there you're trying to say, well, what is the nature of the owner's claim? And the fact that the owner puts a particular badge on it won't be determinative, but that's the standpoint you're looking at. Then when you get into other categories, most notably 2.1f, which is basically when you incur costs mitigating a loss that would otherwise be limitable. So a good example might be you spray firefighting water onto the vessel to stop further limitable claims. If you then have to remove the firefighting water, you might say, well, that's a cost of mitigation. That was one of the arguments. And there you're looking at it from the perspective of why was that action taken? And was the Supreme Court says, is the dominant purpose of the action to mitigate a limitable loss? So the answer is these questions are difficult to answer, and it sometimes depends on which limb of Article 2 you're looking at as to whose perspective really counts. But you're still, even after the Supreme Court, left with difficult questions to answer. So, for example, under 2.1e, if the claim is for removing cargo, well, the court says, well, that is limitable in principle. But if you've got a large casualty on a container ship, where do you draw the line between something that is cargo and therefore limitable and a container that is molten and full of gunk that you need to then just take off for the purpose of repairing the ship? When does something cease to be cargo and therefore cease to be within 2.1e? These are difficult questions that are for another day, really, and another case.
So then that's an interesting question. And again, we kind of see that when stress tested, some of these the convention wording is, probably because the cases are so few and far between, right? And you don't have the wealth of authority that you might have on, say BPGTCs or NYPE form. But you do have all of these open avenues and open questions about, as you say, when does cargo cease to be cargo? It's and that then, in this instance, leads to questions of whether or not something is covered by the limitation. And
it really matters as well,
right?
This isn't these cases where you have the big casualties. This is the difference between getting 28 million and 200 million. I mean, it's not like it's a trifling issue where it's makes a marginal difference. As it happens, with the result in the Supreme Court, you'd have a limitation fund of 28 million odd, and you would be able to limit only in respect of the cargo claims under 2.1e. Actually, in the end, it wouldn't, the value of those claims means that you'll probably satisfy most of them through the fund, if not all through the fund. But at a high level, it really matters.
Yeah, because as soon as you have a limitation issue, you are talking about a high value claim, given the size of the vessels that are typically that we would typically see in our day to day, and the accordant limitation. The size of the limitation that would come out of a vessel of that tonnage. As we say, the limitation is based on the size of the vessel. If you're thinking about engaging a limitation argument, then necessarily you're looking at a pretty serious claim. So in the end here, and again, apologies, I'm asking a silly question, but when I was looking through the judgment, the way the claim is presented to the Supreme Court appears to be in part because there's a fairly broad settlement agreement which is agreed prior to the decision getting this far. But obviously that settlement agreement has some mechanism where it's in some way contingent on, or some part of the loss is still to be determined by the Supreme Court. And I think that the claim as presented, or the appeal as presented in the Supreme Court, is therefore limited to certain categories of loss. And do those correspond with the losses that the Court of Appeal found would fall within the limitation, or were there other losses outside of those that also form part of the Supreme Court appeal?
So I can't talk about the settlement
without reading the settlement agreement, if you want. Right. But just on its face,
it's public information that there was a settlement between the Court of Appeal judgment and the Supreme Court. And I think it's, but the parties agreed that the Supreme Court should hear the claim in any event.
Okay.
Because of the importance of the issues for the maritime community. I mean, it won't surprise you to know that obviously there were insurers behind part of
Yeah,
it.
of course.
That's no shock there. But broadly, the categories of claim broadly stay the same going up through the appeals. So I think there are a couple of categories where points were dropped as between, I can't remember exactly now, between Admiralty Court stage and Court of Appeal, and then Court of Appeal and the Supreme Court. But broadly speaking, you're looking at trying to shoehorn the same sorts of claims into the same provisions of Article 2.
Yeah. And if it is the case, and I'll ask you to comment on this is maybe something for Luke to comment on. If it is the case that that things were wrapped up entirely with a settlement agreement, but the parties agreed and their insurers agreed, or their insurers wished for this to be heard by the Supreme Court, that underlines not only the rarity of this type of case, but also the importance of having some clarification around what these conventions mean, and the fact that this case falls kind of neatly in the grey areas where a Supreme Court decision is helpful.
Yeah, I can take that rather than put David on the spot on what insurers may be thinking. But yeah, I think that's fair to say. I don't know who's involved behind the scenes on this case, but there's certainly, and we see this not just in this case, but in other cases as well, where P&I clubs, commercial insurers, hull machinery and what have you, where there's some general interest in understanding the limits of certain conventions, because as you and many who listen in will appreciate, the way that insurance is rated, the way that risks are underwritten, is on the basis of what could be the potential exposure. And so it's in everyone's interest, really, to understand where those limits are and to be able to set premium accordingly moving forward, so that there's less surprise. And that can go both directions. That could lead to an increase in premiums. It could lead to a decrease in premiums. This is a kind of fluid market. And so there are cases, and perhaps this is one of them, where there's an interest in having clarity around what the law says about certain things, particularly here in an international convention. So, yeah, it's a good point.
Previously, obviously, you had the CMH castle that went to the Court of Appeal, and that settled before the House of Lords got their hands on it. So, sort of limitation things, issues get tantalizingly close to the highest court, and then suddenly they're snatched away sometimes.
I suppose the sums involved is such that maybe the roll of the dice is not seen as being worth it for when it could potentially end up with such a significant change in the quantum that the insurer or the assured is facing.
Point we haven't touched on so far is the additional point that we haven't touched on so far is there were also proceedings in the US. So that's in the background to all of this. There's a massive piece of litigation in the US as between the shippers of the dangerous goods,
right,
the charterers, the owners, etc. And so that's going along. That process took forever, and the appeals took forever. And so alongside that, you've then got the arbitration between owners and charterers, then the limitation, and that the US proceedings came to an end fairly shortly before before the Supreme Court. So got its hands on this one. So
that's interesting, because I was going to ask what became of the cargo interests who put this cargo on board and started this whole chain of events.
Yeah, well, there's a couple of judgments from District Judge Forrest in New York that deal with who's responsible for all of that. That's, as you rightly sort of allude to, that's where ultimately the responsibility for everything that happened lies, albeit as between owners and charterers. In the arbitration, the responsibility fell on charterers.
Yeah, it's one of the other kind of fascinating areas of this, or fascinating parts of this area of law, is the number of parties involved, the tension between different courts internationally, and the fact that you end up with litigation dotted all over the globe. In this case, you've obviously got arbitrations in London, you've got decisions through the English courts, and then, as you say, presumably the Southern District of New York is having its own involvement.
And also the enforcement proceedings. So again, if you have a look at the first Flaminia judgment in the High Court, that touches on the enforcement efforts that were effectively going alongside the limitation action, with the owners seeking to enforce the arbitration award through other means.
And if you are able to say 8 or 9 years on, is the Flaminia file closed off your desk, or are there still satellite pieces of litigation that continue to keep you busy?
It's, so far as I'm aware, it's closed.
File is closed. It must be one of those which is kind of closed with a degree of relief, but also a sort of a sense of fondness.
Yeah. I mean, it's a great team to work with, and when you kind of get used to dealing with a case for the best part of a decade, it leaves a void in your life. But yeah, I'm not sure there's any more rounds that this particular ship can go through. As I understand it, it's happily sailing around the world still. So
you'll have to just write a book on it one day.
I don't want
2 mentions of a book, and I've noted it hasn't been taken up.
No way. I'm not doing limitation.
Any other final thoughts or points that kind of came out of this judgment of broader applicability that we've not touched on?
I don't think so. I mean, as I say, I think the takeaway is that it provides clarity on certain issues which we've been lacking, but it does still leave other issues yet to be resolved, and particularly around, well, where do you draw the lines between certain things? The 2-1F, what does it mean to say that the dominant purpose has to be for mitigation? Under 2-1E, where do you draw the line between a bit of metal that's become welded to the ship in the course of a fire that was once part of a container, and cargo, that sort of thing. So all of these things will be for another day. And as Luke also touched on, now that we know the extent to which charterers can limit, at least we have greater clarity on that. Does that mean that we actually should be looking at where the limits are set in terms of SDRs? And does that need to be reconsidered in the future as well?
Was there a sense that you would get some kind of arbiter or some kind of clarity on some of these points? Or because I felt reading to a judgment that it's obviously goes without saying the Supreme Court always invariably write excellent judgments, but sometimes you see Supreme Court judgments that are very on point and they don't really stray from the course. Where sometimes you have Supreme Court judgments where they will take the opportunity to really clarify a number of things in that area of law. And it's all obiter, but obviously a Supreme Court obiter, you might as well be carving it in stone a lot of the time because it's particularly something like limitation. To go against it would be a big thing. This feels like it's more in the former category. They kind of stayed true to the brief. And was there ever a sense that they would take the more expansive approach, or did this always feel like a case where it was going to be quite narrow?
Well, I mean, the parties were there for guidance for the market more generally, really. So there was always a chance that the Supreme Court might have taken the opportunity to be even more expansive. But, let's face it, some of the issues around, for example, paying your own claim are not easy. How does that get resolved? That's not easy. The Admiralty judge came up with a solution that he thought was a solution. The Court of Appeal thought it was not a solution because they'd never heard of it and never seen that happen. And the Supreme Court said, well, let's wait and see for another day how that all works. So, I can understand why they might want to dodge that.
Save it for another midword to review course. Yeah,
Exactly.
Well, if the case comes up, any of our listeners are in need of a barrister who knows the terrain, then I've got a recommendation for them.
Absolutely. Well, look, thank you very much for your time, David. I've enjoyed discussing this case, and to have someone like yourself, who knows it so well and has been involved for years. It's a real treat for us and for our audience, and I'm sure they've enjoyed the discussion. And thank you for listening in to everyone out there. Hope you got something out of this pod. If you've got questions, by all means, send them David's way, our way. Happy to have any follow-ups on this. And so to say thank you, David.
Absolute pleasure. Thanks for having me.
Hugely appreciate it, David. Thank you for your time.
All right. Thanks, chaps.
See you next time, everyone. Bye.